On December 13, 1971, a pregnant woman by the name of Norma McCorvey sued the state of Texas for not allowing her to get an abortion. This case was about the 14th Amendment and installing privacy. They believed that the privacy expanded to the fetus that the woman was carrying. This case stayed open and was being tried for almost 55 years until it was overturned in June of 2022. The final verdict was that it was left up to the states whether or not women were allowed to get a legal abortion. On February 20th, 1958, a member of the Little Rock Independent School District Board named William Cooper sued John Aaron because he denied the school board the right to delay racial desegregation. Cooper wanted to spread the racial desegregation over the course of 2 years, going little by little. This case lasted only 7 months before the court ruled in Aaron's favor. However, another part of this case was whether or not the state needs to follow what the government says to the letter, or can they just improvise on what they have been given. In December of 1965, Mary Beth Tinker and a few other students from Warren Harding Junior High School in Des Moines decided to wear black bands around their arms to protest the war in Vietnam. They were then suspended from school and black bands were banned. Mary Tinker's parents then decided to sue the school for violating their First Amendment rights to display freedom of speech and freedom of protest. The case lasted 4 years before the court ruled in Tinker's favor. This case set precedents for every other students' rights case and how the court handled it.
Marbury v. Madison. With his decision in Marbury v. Madison, Chief Justice John Marshall established the principle of judicial review, an important addition to the system of checks and balances created to prevent any one branch of the federal government from becoming too powerful. Madison legal case in which on February 24, 1803, the U.S. Supreme Court first declared an act of Congress, thus establishing the doctrine of judicial review. The court's opinion, written by Chief Justice John Marshall, is considered one of the foundations of the U.S. constitutional law. The Wisconsin v. Yoder case is about how Wisconsin had a law that implied that you have to take your kids to school until the age of 16. But Yoder did not want their kids going to school because they did not want their kids learning about the worldly ideas in high school because they feared that it would mess up their religion and their practices. So they took their kids out of school in the 8th grade, breaking the law. Since they broke the law, they were each fined with $5. So they went to the court and they explained that in the First Amendment that they had the right to exercise their religion as they pleased. The court sided with Yoder, and they got to take their kids out of school. The Harvard and SSFA versus UNC case is sitting for UNC unfairly uses race to give significant preference to underpressing minority applicants to determine of white and Asian American applicants, while ignoring race-neutral alternatives for archiving a diverse student body. Harvard wanted Asia to be at their school because they did not have many people by that race, but later in 2018, 80% of the school was Asian and white. UNC later tried to sue Harvard, claiming that they should not let people in just because of their race, and they should fairly judge all student applicants.
While still in Sweden, Fiker filed a lawsuit against the FBI, claiming violation of his Fifth Amendment right to due process. While the lawsuit was pending, the FBI removed him from the no-fly list. A federal district court in Oregon dismissed Fiker's case as moot given that he had been removed from the no-fly list. This case was a landmark decision of the Supreme Court of the United States, in which the court anonymously ordered President Richard Nixon to deliver tape recordings and other materials related to the Watergate scandal to a federal district court.